SA Explained here on ENCA. Nqaba Mabece, the host of this podcast, my first, so please bear with me. Let's talk about S versus Sibanyoni and others. It's a high-profile case, particularly at the time at which it is happening, with the fallout coming through from Madlanga. And I want to draw this because this is why we are doing first this podcast, and perhaps to use this as an opportunity to advance our collective understanding of criminal law, particularly as it pertains to bail applications and proceedings, and what it means when a matter is struck off the roll, and the implications for the prosecuting authority, particularly the National Prosecuting Authority. Joe Ferrari is charged with money laundering as well as extortion. Serious commercial crimes. Under normal circumstances, these are almost always opposed in the bail application proceedings. This case was no different. This happened on the 18th of May, 2026, obviously, where the first appearance or the first hearing in relation to the bail. What happened there? The prosecutor, and I'll get the name very shortly, was instructed by the court on Friday for the proceedings that were taking place on Friday to continue on Monday. The prosecutor says, I'm not available to do so on Monday. Not that I'm not available at all, I'm just not in a position to do that on Monday. Magistrate instructs the prosecutor to be there on Monday. And this is instructive in terms of what later we are going to be dealing with. Are these charges serious? Money laundering and extortion, very seriously. They're associated with proceeds of unlawful gain as well as organized crime. So one can imagine the far-reaching consequence this is. Not least because money laundering has a direct impact on the ability of the country to generate revenue through SARS and ultimately to be distributed for public service that all of us are entitled to and should enjoy. So this is the level of the pitch of where this charge or this crime is alleged to be at. It's high. I'm not so sure, so please don't quote me on the schedule offense that it is. The accused made an appearance, obviously, before the 18th. So I'm going to assume the 18th was the second, at least, appearance in relation to this matter. And presiding over the matter was Magistrate Thulethu Tonjeni in Mpumalanga. The bail application was obviously opposed. The state opposed the bail. This is why the matter was still in the process of continuing bail on Monday, which would have been yesterday, and for however long it would continue going for. So what happened? The matter was struck off the roll. What does it mean when I say a matter is struck off the roll? A matter is struck off the roll for a variety of reasons, and I'll get into the Criminal Procedure Act's relevant section that directs us in relation to that. Crucially, what you should know at this point is this. This is not to say those who are charged do not have a case to answer to. It simply means on present facts, they are not being charged. Why? For whatever reasons, the NPA could not proceed with the matter. And in the view of the magistrate, this matter should be off the court roll until and unless the National Prosecuting Authority is ready to proceed and does not, among other things, cause undue, unreasonable, and or inordinate delays. So this is not an indictment on the NPA from a merits perspective, but purely from a procedural perspective. That's why the matter was ultimately postponed and struck off the roll. Who represented the state? Advocate Mkhuseli, or Kusta, as some would know him to be, Nqaba. He is the person who now is at the center of, let me call it, a storm. You obviously know what happened. What are the reasons that were given for his non-appearance? I am not sure, and I'm not aware of what has been reported out there. Crucially, he is not missing. He was just absent. And we can certainly come to that conclusion because he gave or suggested that he would not be there on Monday in the appearance that was taking place on Friday. Reasons are not known, but Nqaba had indicated on Friday that he would not be available on Monday. However, despite this warning, the magistrate ordered him to attend court anyway. These are now some of the issues we have to grapple with, and perhaps in a subsequent podcast, and as news around this matter unravels and so we get more intelligence, we will know. And maybe at the appropriate time we shall get a criminal law expert in terms of what happens when a presiding officer instructs, but for the parties who are represented, the state and the defense, are not able to honor that instruction. This is nothing more than diary management when broken down to the net effect. It's not something which can be classified as the kind of contempt of court sounds like. It's a question of diary. I'm not available. I'm making it known to the court. I'm not available on on Monday. I don't know what the reasons are at this stage, but that's all Nqaba is said to have done. And that is the basis of not only the case itself being struck off the roll, but his being held in contempt of court. Contempt of court is what? Disobedience to the instruction and authority of the magistrate of the court, whose role it is to ensure the proper, effective, and efficient administration of justice. So from these issues, you can already tell that there will be two schools of thoughts as they relate to whether or not this was an even-handed approach by the magistrate, because it was a fair instruction and a fair requirement for the member of the National Prosecuting Authority to present and lead the state's case on behalf of the public, or the reason, which was tendered in part at least on Friday, would under normal circumstances suffice for the matter not to proceed with him there at least on Monday. I do have a couple of questions at this point. Is it not possible, given the fact that it's not Mr. Nqaba's case, but that of the National Prosecuting Authority, could somebody else have represented the NPA in that matter? I don't know. You see, I've never really practiced criminal law, so it's my interpretation of what sounds to be reasonable or otherwise, bringing in obviously constitutional injunctions, including but not limited to the right to be presumed innocent unless and until proven guilty by a competent court, which this is. So Sibanyoni is not guilty of anything unless proven otherwise. He has the right to access to courts, and this instance would have been a denial of him having access to court. He was told to go there on a particular day. He was there, and the state was not there. So already the NPA, at least on those facts, is not painted in a good light. Were the reasons of Mr. Nqaba sufficient? Let's assume they were sufficient. The question then I have, and I don't have an answer to this, is why could the court and the NPA not come to, together with the defense, obviously, a decision of when to proceed or how to proceed? Remember, I say it's the National Prosecuting Authority that leads the case through Mr. Nqaba. It's not Mr. Nqaba's case. So why could the NPA, if Nqaba knew what he knew on Friday, that he wouldn't be able to present the NPA on Monday, get a junior, get somebody else to run the state's case? Or why did the magistrate insist that Monday had to be that day? Now, let's pause here for a second. Struck off the roll. I remember as a law student at the University of Fort Hare, Judge Herbert Msimang, 2006. He struck off the roll a case that would have far-reaching consequence for the National Prosecuting Authority, specifically Billy Downer, who at the time was Advocate Billy Downer, leading the case on behalf of the state in the Zuma matter. Thales Tint, I don't have to go too deeply into that. Surely you know that. The NPA had dropped the ball on a series of occasions. The language that the late Judge Msimang uses is they went from one disaster to another. And his decision to come to strike the matter of the roll, he characterized it because of all these issues leading up to this point. The chickens had come home to roost. He was left with no option but to strike the matter off the roll simply because of the poor preparation on the part of the NPA as at then. Do these circumstances mirror those circumstances of 2006? On the face of it, I'm not so convinced. It was in the early stages of the bail application process. It was defended by the National Prosecuting Authority. They had been in custody for a week, possibly a couple of days longer, but it wasn't long. And it's a bail application. Now, these people, where the state was opposing the bail application, are among us again, despite the serious charges that were preferred against them by the National Prosecuting Authority being extortion. So there's every reason to think that it's quite possible for them to be continuing with whatever would have led them to have these charges filed against them or preferred against them, extortion, including and not limited to money laundering. So this is where we are at. Things are yet to unfold, but the Criminal Procedure Act is instructive here. Let me just try and find in relevant part what we are dealing with here. 342A. 324A, I think it is. My papers are not quite in order here. If my lady could just indulge me a minute or two, please. This is the language that is deployed in court. Anyway, it doesn't appear, but suffice to say, A matter can and must be struck off the roll if, in exceptional circumstances, it causes an unreasonable delay. It's an affront to the authority of the court. I'm not so sure from what little we have heard and or learned from this, the threshold, if I can call it that, has quite been met. But also imagine what this does for the integrity of the NPA. It is heard. Can you imagine if for whatever reason you cannot make court, if not on time at all, that this might be the consequence, that your case is struck off the roll, and worse, despite you offering the suggestion that you wouldn't be able to make it, a warrant of arrest is issued against you? And let's talk about that. What is a warrant of arrest? A warrant of arrest is essentially you being charged for contempt of court in this instance. Who's going to run that prosecution? The National Prosecuting Authority. The magistrate is a witness in the matter, so she cannot preside over this matter. So you can see already the convolution of matters already at this early stage. It's highly politically sensitive, charged, and this is far from the last we would be hearing from this. And having said that, I will be back, hopefully with better facts, because they would have been ventilated in open court, and the public would have had an opportunity to engage this. But it is damning that the National Prosecuting Authority, together with the magistracy, have come to this level. Clearly, there's an element of distrust here, or lack of respect, one way or the other. I would suggest at this point, from the facts we have, there was not an even-handedness in coming to the conclusion that the magistrate came to. Strike the matter off the roll, as well as hold the NPA's advocate, in this case Nqaba, in contempt of court, and such that a warrant of arrest for him has been issued. It continues, no doubt. With me, Nqaba Mabece, this has been SA Explained.